defendant was on the 6th floor of the rooftop bar. The defendant picked up a chair, threw it off the 6th floor. The chair landed on Broadway, approximately 3 feet from where Officers Gavin Treese and Officer Yaroslav Holokov were standing, placing them in imminent danger of death or serious bodily injury.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Back in April, about maybe a month after I started doing content for this channel, I woke up to the news that country music superstar Morgan Wallen had been arrested for 3 counts of felony reckless endangerment after he hurled a chair from the rooftop of Eric Church's bar in Nashville. Now, the chair landed, I guess, in close proximity to Nashville Metro police officers. Well, last Friday, Morgan Wallen entered into a plea agreement with the state of Tennessee where he agreed to plead guilty to 2 counts of misdemeanor reckless endangerment. And as part of the agreement, he got consecutive sentences of 11 months and 29 days for a total effective sentence of 2 years. And so for the period of the 2 years, he would be on probation, supervised through the court, and then he also would be entitled to a diversion under the law, which, if you don't know, a diversion essentially is like a way to hold this over your head, but magically washes it away if you do all the things that you're supposed to do during the period of probation. Now, the case did end in substantially the way that I predicted because I originally did cover this case, although my channel was new, and I think less than 1,000 people even watched the video. So most of you, if you're watching now, have never seen my take on the Morgan Wallen incident. But just for context, let's go back and take a look at the case of Morgan Wallen, what actually happened, and then we'll come back and talk about some of the legal points.
It's a News 2 breaking news alert.
And that is country music star Morgan Wallen has been arrested. There was some sort of incident in a downtown bar that happened last night. Peyton Kennedy just watched him leave Metro Booking a short time ago. She is live there with the information about the charges that Wallen's facing.
Yeah, Neil, Morgan Wallen just made his exit here within the last half hour, making a very quick move to his car. But we were here, caught it on camera, and we'll show you that video now. So according to the arrest affidavits, Wallen was on the 6-story rooftop of Chiefs, which is a brand new bar on Broadway, when he reportedly threw a chair off the roof. Records show that it hit the ground about 3 feet away from 2 Metro police officers who then went to investigate the incident. Wallen is reportedly caught on camera lunging and throwing the chair off the roof, and witnesses say that he was laughing afterward as well. So he is charged with 3 counts of felony reckless endangerment with a deadly weapon. He is also charged with disorderly conduct for creating a hazard that served no legitimate purpose. His lawyers were here as well. They shared their information with me, so we'll be reaching out for a statement, and we'll share that as we receive it here on News 2. Live in Nashville, Peyton Kennedy, News 2.
So, reckless endangerment under Tennessee law is by default a Class A misdemeanor, meaning in Tennessee we have 3 categories of misdemeanors. We have a Class C misdemeanor, which is jailable up to 30 days. We have a Class B misdemeanor, which is jailable up to 6 months. And then we have a Class A misdemeanor, which is 1 day less than a year, and it's 11 months and 29 days. If the instrument that a person is using in the course of committing the offense of reckless endangerment is a deadly weapon, or by its intended use can be articulated as a deadly weapon, then that person can be found guilty of Class E felony reckless endangerment because it's done with a deadly weapon or an item used as a deadly weapon. An E felony under Tennessee sentencing guidelines is 1 year to 2 years maximum in the Tennessee Department of Correction. Well, in order to prove that a person used a particular item, in this case a chair, intentionally as a weapon designed to cause death or serious bodily injury, one of 2 things has to be true. Either the thing has to be a traditional weapon, gun, knife, sword, something like that, or the state has to prove that the way that the defendant used it and the defendant's intended use of it was to cause serious bodily injury or death. Well, the issue is this. If I were to throw a chair at somebody, if the state could prove that I was throwing the chair at that person, they would charge me with assault. They would charge me with aggravated assault because the thing that I'm using to throw at the person is obviously intended to cause some damage to them, to cause serious bodily injury or death. But it gets a little layered about the assault. So if we look at the Tennessee assault statute here, 3913-101, a person commits assault who intentionally, knowingly, or recklessly causes bodily injury to another. Or 2, intentionally or knowingly causes another to reasonably fear imminent bodily injury. Or 3, intentionally or knowingly causes physical contact with another, and a reasonable person would regard the contact as extremely offensive or provocative. So if we go over to the aggravated assault, which is 3913-1004, the code spells out that a person can commit aggravated assault who intentionally or knowingly commits an assault as defined under the previous section, and that assault results in serious bodily injury to another, or results in the death of another, or involves the use or display of a deadly weapon, or involves strangulation or attempted strangulation, or you can do it by doing something recklessly. So you can recklessly commit an assault, so you can commit the assault, and then the recklessness would be the mental state where you basically intentionally disregarded a substantial risk. That's what recklessness is. And then as a result of your conduct, the person experiences serious bodily injury or death. So when we look at the reckless endangerment statute, which is 3913-103, a person commits an offense who recklessly engages in conduct that places or may place another person in imminent danger of death or serious bodily injury. So the reason this is not charged as an assault is because they can't prove that it was intentional. So they can't prove that Morgan Wallen was like, hey, I'm going to throw this chair at that person. And there's no serious bodily injury because it didn't actually make contact. And because they can't prove that he intended to make contact and it didn't actually make contact, that's why this case is charged as a reckless endangerment and not an assault. It can get confusing because reckless endangerment also has a reckless intent standard. But this is also an appropriate reckless endangerment charge. But the difference is that they charged him with a felony. And again, in order to get to the felony, you have to prove that he intended to use the chair in a manner that would cause serious bodily injury or death. And if you could prove that he intended to do it, they would have charged him with assault. And that's the argument I made in my initial video, which was really bad because it was like 40 days into my YouTube channel, and so I'm not going to make you sit through it again. But because the state could not prove what his intent was, because all he did was hurl a chair, and I say all he did, not to minimize it, because it was stupid, and it was an irresponsible and reckless thing to do, and it's absolutely reckless endangerment. It's just not felony reckless endangerment. Now, if he had said to his buddies, and it was on camera, hey, look, there's 3 asshole cops standing down there, and we'll toss this chair at him, ha, 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 and he tossed it over, now they would also charge him with aggravated assault, and they would charge him with reckless endangerment for, somebody else that may have been close by or whatever, right? So you could have a situation where you could have reckless endangerment and aggravated assault for 2 separate victims, and that would be okay. But in this particular case, all he did was he threw one chair without even looking who was down there, which is the recklessness part, right? And it happened to land within feet of 3, protected class people of, police officers, right? I say that in jest because it would have been the same whether it was citizens or police officers. But the reason they wanted this specific thing prosecuted was because, let's be honest, he threw it and it landed around a few cops, right? So the point I'm trying to make is they couldn't have proven felony reckless endangerment here. Now, again, there's only 3 things that matter in a criminal case. And there's actually only 3 things that matter in any case, and that's the facts, the facts, and the facts. And so we don't have all the facts, at least I don't. So I don't know what witnesses might have come forward. And maybe you had witnesses that were going to come forward and say, yeah, exactly what I just said in the example. Okay, I'm going to throw these down there and see if I can scare these cops, right? I believe that they didn't have that evidence, and the reason is because he didn't ever get a superseding charge of any kind. But what I find curious about the case is that he's got this high-profile Nashville lawyer named Warwick Robinson IV, who was the lawyer who represented the ex-Vanderbilt athlete that was convicted of rape, and he's been involved in several high-profile Nashville cases. And this lawyer pled him to something that absolutely could not have been achieved in court, and I don't understand why.
The defendant was on the 6th floor of the rooftop bar. The defendant picked up a chair, threw it off the 6th floor. The chair landed on Broadway, approximately 3 feet from where Officers Gavin Treese and Officer Yaroslav Holokov were standing, placing them in imminent danger of death or serious bodily injury.
On the other hand, if you do not successfully complete your probation or you have other arrests or trouble with the law, you run the risk of losing your judicial diversion status. And if that happened, these offenses convert to convictions on your record. Do you understand that, sir?
I understand.
Mr. Wallen, did you hear the facts as read by the Assistant District Attorney?
I did hear
Are
that.
those facts true and correct?
Substantially, yes.
Are you waiving your right here today and entering a plea of guilty in your pending case?
Conditionally guilty, yes.
Conditionally guilty, yes, ma'am.
In case number 2024 I-687, where you were charged with 2 counts of reckless endangerment, how do you plead, sir?
Conditionally guilty.
First of all, you cannot be convicted of more than 1 count of reckless endangerment in Tennessee for one single act, even if it endangers multiple people. And there's a case on this. There's actually multiple cases on it, but the one that I find that's probably the most recent that gets cited more is this one, State versus Cross, the state of Tennessee versus Lonnie Cross, and that is a Knoxville criminal appeals case. And so essentially what the court said in this case is that it's double jeopardy. It's a violation of double jeopardy to suggest that a person can do one thing and be punished twice. If we go through the opinion, it's the double jeopardy clause of the Fifth Amendment of the United States Constitution. It says no person shall be subject for the same offense to be twice put in jeopardy of life or limb. And it says similarly, Article 1, Section 10 of the Tennessee Constitution states that no person shall for the same offense be twice put in jeopardy of life or limb. These double jeopardy clauses protect an accused from a second prosecution following an acquittal, a second prosecution following a conviction, or 3, multiple punishments for the same offense. And the present case involves the third category. Anytime you have more than 1 count of something, you can get consecutive sentencing if the state can prove one of like 7 or 8 factors. So I'm not going to go through the factors because they're not relevant here because he agreed to it. But the court, if they find, like one of them is like you're a career offender, you show a disregard for life and whatever, you're on paper of some sort, you're on parole. There's a bunch of different factors, right? If they can prove any one of those factors, the trial court can appropriately sentence a person to consecutive sentences. So you might commit 2 counts of reckless endangerment that are 1 to 2 years, and the court can impose 2 and 2 and run you for 4 years. And that is the reason that double jeopardy would be in play when you've only done one thing. If you take a person and they commit a Class A misdemeanor, and that means that they're exposed to 11 months and 29 days of incarceration, potentially if they're convicted of that crime, and you charge them with 2 counts simply because there were 2 people standing there when the chair hit the ground, well, that gives the court, say like a Davidson County Nashville court who hates Morgan Wallen, the opportunity to say, oh yeah, well, let's give him double the punishment for he only did one thing. He threw 1 chair. There were 3 people around, right? So again, I'm not defending Morgan Wallen. I think what he did was reckless and he could have hurt somebody and somebody that wasn't a cop. And so I'm not defending him, but my concern is that if they get by with it with Morgan Wallen, typically we see the reverse dynamic happen. We see celebrities who get away with stuff that ordinary people wouldn't get away with. And you've got this guy who's got millions and millions of dollars and he hires this high-profile lawyer, and that lawyer pleads him to something that a 1 year out of law school public defender in Nashville could have beaten at trial. And I don't understand how this happened. I really don't get it. And there's a second case I'm going to pull up here. State of Tennessee versus Betty Norman. In this particular case, what the person did was after some argument or altercation that she had with somebody, she fired a round into the door of a residence, and there were multiple people inside the residence. And so they convicted her again and said, well, they're going to give her, multiple counts of reckless endangerment. And the court said, no, she fired 1 round into the house. And to the extent that you could punish her for something for that, it has to be 1 punishment. She committed 1 crime, even though there are, several victims who could have been wounded. So it says, although not raised by the appellant nor the state of Tennessee, this court notes that the appellant has 2 convictions for reckless endangerment as a result of her shooting the door at the Norman residence. However, this court has held that the act of firing a single shot constitutes only one act of reckless endangerment, regardless of the number of victims endangered. In this case, the appellant was convicted for firing a single shot into the door at the Norman residence, and only one conviction for reckless endangerment was therefore proper. As a result, the appellant's conviction for reckless endangerment in count 2 is vacated and merged into the appellant's conviction for reckless endangerment in count 1. But in closing, all I'm saying is that this lawyer, who I'm sure got paid a boatload of money by Morgan Wallen, pled him to 2 counts when there's tons of case law suggesting that that is an illegal sentence. And if you don't have 2 counts, because he only got charged with one thing, right? He got charged with 3 counts of reckless endangerment, 1 count for each of the victim, which again is improper based on case law. And if you don't have the 2 counts, there's no way he gets 2 1129s running back to back. Now, it is true that you can agree to just about anything. You can agree up or down sentencing. You can agree to almost anything by choice or by consent in a plea agreement. But I don't understand why the lawyer would plead him to consecutive 1129s when there's tons of case law to suggest that that isn't even possible. Now, what is possible is he could have gone to trial and lost because it was clear that he was guilty of reckless endangerment, and this court could have incarcerated him for 11 months and 29 days to serve. But I don't think that was very likely because I don't think he has much of a criminal history. In fact, I know he doesn't have a significant criminal history because in order to be entitled to a judicial diversion in Tennessee, you can't have a previous conviction of a Class A misdemeanor or higher. So the fact that he's getting a diversion and eligible for a diversion means that he didn't have any criminal history that would disqualify him from the ability to get a diversion. And so I think he would be entitled to a presumption of probation under the law because he's entitled to a judicial diversion. And so this is one of those cases where I think Morgan Wallen, being a celebrity with a lot of money, got a sentence that was worse than he probably would have gotten had he lost at trial because they could not have proven the felony part of that, I don't think. But I guess there's always the risk and the multiple court dates. And my guess is, and I don't want to blame the lawyer completely because I don't know all the facts, right? And I wouldn't want somebody coming in second guessing everything that I did when they don't know all the facts. If you know all the facts and I screwed up, hold me accountable, fine. But don't go running off at the mouth if you don't know all the facts. And so I don't know all the facts. I don't know why he did this. What I do know is that the client drives the bus. If the client drives the bus over a cliff, I'm strapped in too. And so to the extent that Morgan Wallen said, hey, look, you know what? I'm going to be straight on probation. I'm not going to mess up again. I don't want to come back multiple times. The state's made an offer. Let's just take the offer. It's possible that the state made an offer and the offer was something that they wouldn't have been able to get in court. And Morgan Wallen just said, you know what? I'm out here making money. I'm not going to come back multiple times, come off the road, let this interrupt my life on multiple occasions. I'm just going to plead guilty to it, take the diversion, stay straight. 2 years later, it'll be off my record and no big deal. I don't know if you guys are curious about this case or if you know anything about this case or not, but let me know what you think about it in the comments. I'm sure there'll be some mixed vibes about it. I'm sure there'll be some mixed opinions, but you know, I hated to see this happen just because I don't want to set bad precedent regardless of who the defendant is, on what you can and can't do with sentencing. I just think it's crappy to take a 2-year sentence on a case that couldn't have been proven for 2 counts and would only be exposed to 1129. Anyway, that's all for this one, guys. I thought you might be interested in the update. If you want to support the Southern Draw Law channel, I don't offer any type of memberships, but I will leave my Venmo and PayPal link both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Let me know what you think about this sentence. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.